Well, I think these changes proposed under the ESA are significant, even though they're only at the first reading stage. Pre-pandemic, we often talked about the expanded workplace, which is that the workplace is not limited to the walls of your physical environment, and the workday often extends, after hours. That has only been exacerbated by the pandemic, where hundreds of thousands, if not millions of people have worked from home across Canada, which has really blurred the line between work and home life. And employees have often said, or are often saying, that they're working actually longer hours during the pandemic. So the government's come out with this right to disconnect, which means that employers with more than 25 employees in Ontario will have to have a written policy on disconnecting from any means of communication after working hours, which includes phone calls, video chats, emails, etc. This is very significant, and it'll be very interesting to see what the final legislation looks like. The second piece is the Ontario government is proposing banning the use of non-compete clauses in employment agreements. And we've often said at Rodney Employment Law that if you have a non-solicit, you don't really need a non-compete, and that's been consistent with court decisions across Canada. If you do have a non-compete, it needs to be very limited in terms of geography, time, and the prohibited activities. And quite frankly, over time, we haven't really been encouraging our staff to use non-competes, particularly where a non-solicit is in place. This legislation has the effect of eliminating and making non-compete clauses illegal altogether. So we will continue at Rodney Employment Law and Max People to keep you updated on these two interesting developments.